for taking the time to join us today. My name is Jack Weisbrod, and I'm the sales manager here in Richmond, Virginia. So we really appreciate you all taking the time to come out and join us. We're really excited for this Lunch and Learn. It's great to have this room filled with our community partners, with our clients. So really want to thank you all for taking the time to just join us today. I want to give a quick highlight to our community partner for the day, the Doorways. If you're not familiar with the Doorways, they're a great organization that provides overnight care to folks that are traveling from out of town and need places to stay. If they're here for longer medical events, they offer them a bed to sleep in and all kinds of resources. Dominion Payroll, we were actually fortunate enough to have a couple of folks go out there last week. We did a spaghetti and meatball dinner. I think we put together some care packages for the guests. So it's a really great organization, and I'd like to invite Kevin up here to share a little bit more about himself and the organization.
Thank you, Jack, and thank you everyone for allowing me to have a couple minutes to speak about the Doorways. So as Jack mentioned, we're a nonprofit organization located here in Richmond. We're on 7th and Marshall Street, so just a couple blocks off the VCU Health campus. And we provide lodging to patients and their family members when they come to Richmond, Virginia to receive medical care. So to put that into a little more context, imagine you or a family member living out of town, maybe Southwest Virginia, and you've been on a transplant list for years and years, waiting for that call. And then all of a sudden you get a call saying, we have an opportunity for a liver transplant in Richmond, Virginia. Your surgery is tomorrow. So you drop everything, your support team, your family drops everything and heads up to Richmond to get your loved one this surgery. So the patient obviously will be, in intensive care for quite some time, but what happens to that family member? So we house them in our facility. We're a 117-room facility, like I said, on 7th and Marshall Street, and we suggest a $15 donation per night for our guests to stay. So through surveys and research, 53% of our guests are unable to pay this amount. So that's why we have a team of development and fundraisers that kind of fill that gap through individual support, corporate support, grants, and special events that raise funds to close that gap, to cover those fees, but also invest into our building to provide them more amenities. So what would our guests receive? It's a former hotel, so 117-room hotel. So all the amenities you would expect in a hotel. But my favorite item we offer that kind of comes naturally and intangible is a community that cares. So the volunteers that come in, the staff, the community of guests and families who are there going through similar situations, they bond together, they come together, they support each other, and it's just magical to see. So if any of this interests you, we'd love for you to partner with us. I'll be at the back table after the Lunch and Learn. We can share opportunities about volunteering, our annual fund support, and then our major fundraiser, Saver, that happens each year in March. But to touch on some volunteer opportunities, we do everything from providing meals, care packages, collection drives, and what has become one of our volunteers' most favorite activities and volunteer tasks is having a Windex party. So all of our rooms are outward facing downtown, so it gets dusty and muggy on the windows, especially in pollen season. So we have corporations, groups, church groups, friend groups come out and Windex our whole building. So for those of you who are joining virtually and like to learn more, you can visit our website at thedoorways.org. And again, my name is Kevin Jackson. If you have any questions, thanks so much for allowing us to share our mission here.
Thank you, Kevin. All right. Well, without much further ado, I want to introduce our friends from Williams Mullen. We have Amanda Weaver and Matthew Anderson here joining us. For those online, if you have questions, please put them into the chat box. We'll get to them at the end, and I'll be running the microphone around towards the end as we wrap up with additional questions. So I will turn it over to you all.
Hello. Thank you all for coming today. We appreciate it.
I'm Matt Anderson, as you probably guessed.
I'm Amanda Weaver.
And we're here to talk to you today about what we call the salary fallacy, or kind of the basics things you need to know about the Fair Labor Standards Act, or the FLSA. As you can see from our agenda, we're going to talk about the basics of the FLSA, a kind of a primer on the exemptions. We're going to go in depth on the 3 white-collar exemptions. We'll touch on a couple of the other common exemptions that you see that some people might find applicable here today. And then we'll talk on common mistakes and best practices. But I want to note here at the start, this presentation focuses only on the FLSA, which is the Federal Wage and Hour Law. So it applies to most employers throughout the United States, but many states have their own Wage and Hour Act, or set of laws that govern things like minimum wage and overtime. For example, Virginia's minimum wage is higher than the federal minimum wage. California not only has about 100 different minimum wages depending on which locality you're in, but they also have different overtime rules that depend on things like how many hours did you work this day, how many hours did you work in a week, and the rates for overtime change depending on that. With all of these laws, the goal is to construe them in favor of the employee. They're here to protect the employee. So you can't say, oh, well, federal law trumps state law, and federal minimum wage is lower than state minimum wage, so I don't have to pay the state minimum wage. That's not going to fly. You have to comply with the law that is most protective or most generous to the employee.
Just jumping in real quick by way of further introduction of me and Matt. Matt and I work together at Williams Mullen in our Richmond office. We are both labor and employment practitioners. We do this all day, every day. We discuss these topics, it feels like, all day, every day. So we joked prior to this presentation we could probably just come up here and wing it and hope for some questions and a good dialogue. But these are the sorts of things that our clients are grappling with all the time. And even the most sophisticated clients tend to have some sort of misconception about one exemption or another. So it's always worthwhile to have these conversations and to make sure you are up to speed on what the exemptions are and what you need to be thinking about.
Yeah, I mean, case in point, just this morning I was working with our corporate mergers and acquisitions team on a deal where the seller seems to have fallen into the salary fallacy, and we're trying to get to the bottom of whether that's actually the case and there's a problem for our client buying the company or not. So like Amanda said, we do this all day, every day. All right, so FLSA basics. So this law dates back to 1938. It's funny, I had a client a couple years ago who, we told them, hey, you're kind of out of compliance with this. And he went on a rant about, do people know about this law? When did this come into effect? I think the American voters would be mortified if they knew the things like overtime and minimum wage. And, we just kind of rolled our eyes and said, okay, well. So the FLSA applies to all employers so long as they engage in interstate commerce, produce goods for interstate commerce, or work with goods produced or moved through interstate commerce, and have a gross sales or business volume of $500,000 a year. Not really hard to meet that burden, especially in today's economy where everything goes in and out of all different states and countries.
If credit cards are used, then it's interstate commerce.
Yeah. It can also cover individuals as employers, and it protects all employees, which is defined as anyone suffered or permitted to work. What it guarantees are there's a minimum wage. It's $7.25 an hour for the federal, but as we discussed, it's different in most states these days. And it guarantees overtime, which is for every hour worked over 40 hours in a week, you have to pay someone time and a half. Their regular rate of pay, which
we might touch on later, but that can get tricky if you've got a non-exempt employee who is not making an hourly rate. And then lastly, there are child labor protections in there. So what does it require? We touched on it. $7.25 an hour minimum wage, and then the overtime premium for hours worked in excess of 40 a week. What else is in the FLSA? It defines what compensable time is. I've had clients who they work where all of their employees meet at the office. Well, not the office, but the central location. They load up their trucks with their equipment, and then they all get into the truck and drive to the job site. The FLSA governs when does the clock start, who does the clock, who is getting paid for driving and who's getting paid for riding in the car. It governs how tips are distributed. Particularly, it says if you are in management, you cannot receive tips. It provides for pay equity, restricts child labor, which we talked about. It's where we get the break time for nursing mothers in federal law. Most states have that protection as well. It creates the record-keeping requirement, so if all of you get pay stubs, you can thank the FLSA for that. And it prohibits retaliation, so if you or one of your coworkers thinks, hey, I'm not getting paid overtime that I owed, or I'm not getting paid the minimum wage, and I speak up, the employer cannot retaliate against that person for voicing concerns about potential violations. And lastly, it covers remedies. And this is where things can get really tricky for employers. Because not only, if you violate the FLSA, not only do you have to pay the employees what you owed them, but you also have to pay them a liquidated damage amount, which is a multiple of what you owed them. And then on top of that, you're going to be paying attorney's fees for that employee's attorney. So I want to talk a little bit about the concept of a work week. Every employer should define what their work week is. Is that Monday through Sunday? Is that Monday, is it midnight on Monday through 11:59 on Sunday, midnight on Friday through, you want to have a 7-day period defined. And so you want to look at that period and you want to count the hours that an employee is working in that period. And if they get to 40, once they pass 40, you got to pay them overtime. Well, what doesn't count towards that overtime is things like paid time off. So let's say you've got your non-exempt employee who's paid hourly and they take a day off. And so you put that in your payroll system as 8 hours of paid leave. Well, that 8 hours does not go into the bucket of hours worked. It's actual hours that the employee is actually working. And once you get over that 40-hour threshold, then you're on the hook for overtime.
Okay, moving on to exemptions, which is what we're here to talk about today. Matt gave us a nice primer on the FLSA and what it requires for employers. But then, of course, there are the exemptions to the FLSA, meaning there are certain employees who are not covered by the requirement to pay minimum wage or overtime or both. So before we talk about the specific exemptions that are most likely to come up in your workplaces, we wanted to go over some of the background basics that go into the decision of what these exemptions mean and how they're applied. So the most important overarching takeaway is that the law strongly presumes that employees are covered by the FLSA. An employer, it's the employer's burden to prove otherwise and to establish that a specific exemption applies. So an employee is entitled to minimum wage, they're entitled to overtime unless the employer can prove that a specific exemption applies to them. To decide whether an exemption applies, we're going to look at the duties that are performed because most of the exemptions require certain specific duties as well as skill sets or qualifications. Sometimes we need to look at how the employee is being paid because many of the exemptions have specific payment requirements. including the salary basis or the salary fallacy that we're here to talk about today. And yeah, again, sometimes there is a specific skill set or qualification in order for an exemption to apply. And there's a lot of legal buzzwords behind that that have been fought about in the courts for many, many years and are going to impact whether somebody is truly exempt or whether they should be treated as non-exempt under the FLSA. So the first is the primary duty. The primary duty is the main principal, most important duty that the employee performs. And like many things with the law, there's not a bright line test for what that means. It depends. Sometimes a person's primary duty is the thing that they spend the most time doing. More than half of their time, that would be primary duty. Sometimes it's just the most important thing that they do. But when we're talking about exemptions, and particularly the exemptions that have specific duties requirements, they're always going to talk about the primary duty. It doesn't matter if someone does this one thing for 5 minutes every 2 weeks that might qualify for an exemption. That's not going to cut it. It needs to be the main thing that they do. And the second big thing is the salary basis. The salary basis is one of the most misunderstood concepts of exemptions. Many, not all of the exemptions require that as part of the test for meeting the exemption that the employee is paid on a salary basis. That means that they get a set salary regardless of the quality or quantity of work performed. You can't dock their pay because they weren't in the office in the morning. You can't dock their pay because they didn't do a great job. They're guaranteed a specific salary for each work week with very, very limited exceptions. Currently, the federal minimum salary to qualify for any of the exemptions that are subject to the salary basis requirement is $684 a week, or roughly $36,000 a year. I tell every single client that if you have somebody making $36,000 a year, it's almost impossible that they are an exempt employee, because it is not just the salary that determines whether somebody's exempt. It's also whether they're performing the duties and have the skill sets to qualify for an exemption. And I think it's probably been decades since somebody making $36,000 a year was likely to meet those requirements. In reality, I think we're probably looking at a better litmus test. And of course, there's exceptions for nonprofits and things like that. But currently, the Virginia median annual compensation hovers around $76,000 a year. That's probably a better baseline to think about whether somebody's exempt or non-exempt. But the federal minimum is $36,000.
Yeah, I think that Amanda hit on something important there. There's been a number of efforts over the years to really push this salary basis up, and it keeps getting met with resistance from the court because it's been politicized, and people think, oh, this is trying to create some sort of handout or something. But in reality, it's just pushing this salary basis to comply, to comport more with what reality is. Mm-hmm. People who are doing the tasks that these exemptions were created to cover are not making $36,000 a year. In fact, many of them probably are getting, closer to $100,000, $75,000 to $100,000 a year to do these things. So if they're truly exempt, which we'll talk about here. So we're going to get into what we call the white collar exemptions, which are the most common most people are going to come across in the workplace. There's the executive, administrative, and learned professional exemptions. With some narrow exceptions, these all apply the salary basis test along with the duties test. So let's dive into the executive exemption.
We'll save the administrative exemption, which is the most misunderstood for Matt to tackle, but I'll talk about the executive exemption first. So for the executive exemption, again, this is one that requires the salary basis, and the employee has to be paid on a salary basis of at least the $36,000 a year baseline. But then on top of that, they have to meet the specific duties test, meaning that their primary duty has to be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. So that's one prong. The concept of performing management duties, which means not only kind of supervisory duties of other employees, but duties related to the management of the business decisions of the company. Also, people tend to overlook this, but they have to manage a specific unit of the company. And it doesn't necessarily need to be a specific department, but it needs to be a specifically defined team. It can't just be a random assortment of people. So that's one aspect of the exemption. And then for an executive to be exempt, they need to customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent. So 2 full-time employees, 4 half-time employees or more. And to be supervisory, they need to, if they're not the sole decision maker for decisions related to hiring, firing, promotion, pay, discipline, their input has to be given considerable weight on those decisions. Personally, I lean to err on the side of caution. It really should just apply to the folks that lead the decision making for the folks that they supervise. The primary example of getting it wrong is, there's a slew of cases and issues for assistant managers in retail and restaurants where the individual may have some kind of shift supervisor responsibilities, but they're not the ones that are actually making the decisions about hiring, firing, scheduling, discipline, or things like that. And if that's the case, then this exemption is not going to apply to them. There is also a special rule for business owners, anybody who's a bona fide owner of 20% of equity or more in the enterprise and is actively engaged in management will be exempt as an executive.
All right, the administrative exemption. This is probably the most common, and as a result is the one that is most often the problem exemption. So again, this is one that's based on the salary basis, so they got to make that $684 a week. And their primary duty must be the performance of office or non-manual labor. Again, we're in the white collar world here, so construction workers, people who are in manufacturing, they're automatically out of this exemption. And the work has to be, again, related to management or the general business operations of the employer or the employer's customer. So, someone who's working internally or someone who, would be like an account executive or, the person whose primary job it is to help the customer. I say that because we're here at Dominion Payroll, and I imagine that there are a lot of people here working here who their primary job is to help their clients, their customers run their business, run their payroll. So it's actually running the business. It's not, we're distinguishing that from producing things or selling things or maintaining products or that sort of thing. And that primary duty can't just be some rote, repetitive, here's the rubric, when if this, then Y, then this, if X, then Y. It has to include the exercise of discretion and independent judgment with respect to matters of significance. So what is a matter of significance? Because every job has some sort of, especially in the white collar world, every job has some sort of, where I'm using my discretion and independent judgment. So we're talking about things like policy decisions. We're talking about rules, procedures. We're talking about, there's a difference between the director of human resources and, your HR generalist who reports to that person. And we'll touch on this a little bit in the learned professionals, but there's a difference between your controller and the bookkeeper. It's someone who has, you call someone an administrative assistant. That doesn't mean the administrative exemption applies just because they're earning a salary. And you say, they have really, they decide what paper we order. That's not yes, paper is important to your business, but is not a matter of business significance. So, the statute defines this discretion as whether the employee has the authority to formulate, affect, interpret, or implement management policies or operating practices, whether the employee carries out major assignments in conducting the operations of the business, whether the employee performs work that affects business operations to a substantial degree, whether the employee has the authority to commit the employer in matters that have significant financial impact, whether the employee has the authority to waive or deviate from established policies and procedures without prior approval, and other factors. So, it's the old, if it looks like a duck, it smells like a duck, then it's a duck. So it's more than just what could cost the company money. Like I said, it's high level, essential leadership decision making.
And this is really important, and it's worth some extra time on this particular exemption, because I don't know about Matt, but this is the one where I tend to have the most difficult conversations with clients, because people misunderstand the independent judgment and discretion prong of this exemption. And I often see folks who have looked at that and looked at the fact that the person is paid a salary and said, well, that means that they're exempt because they're exercising independent judgment and discretion. Well, first of all, it has to be for administrative duties. Administrative duties are the back office of the business. So we're talking about, the accounting, the HR, marketing, things like that, but not the service side of the business, not the client-facing side of the business, unless your job is to help clients with their back office functions. But then that independent judgment and discretion prong, Matt touched on this, but it's really important. Every single job, if somebody is paying you money, you have some level of independent judgment and discretion. Unless you are an unpaid intern or a student, somebody is not shadowing you at all times, telling you every decision you need to make. And that can really lead people astray to just get hung up on that requirement, when really it's independent judgment and discretion with regard to very important decisions for the business.
Yeah, and just kind of to echo that, more examples of, hey, this person is our marketing person. They decide, what our social media looks like. They decide, do we buy ad space on radio, on TV? What are we pushing out into the world to bring in, to make our name, to bring in our business? That is someone who is engaged in high level decision making, versus someone who may work in the marketing department, but their job is to take the template that this person or that someone has created and kind of fill in the blanks for X, Y, and Z. That's a pretty good example of the difference that we've got with these what kind of discretion reaches that level and what doesn't.
The last of the big three white-collar exemptions is the learned professional exemption. This one doesn't come up necessarily as much because many of the learned professionals are really obvious. But for the learned professionals, with some exceptions, they must be compensated on the salary basis of at least roughly $36,000 a year. And then they must have a primary duty of performing work that requires advanced knowledge, that's intellectual in character, with consistent exercise of discretion and judgment. And then the important part is in a field of science or learning that's customarily acquired by a prolonged course of specialized intellectual instruction. And we sound like we're reading when we say that, because we are, because these are terms of art that have very specific meanings, and often get misapplied. But intellectual in character is going to mean that the job is distinct from work that involves routine, mental, manual, mechanical, or physical work. You have to use advanced knowledge to analyze, interpret, or make deductions. Fields of science and learning, that's going to be law, medicine, theology, accounting, actuarial computation, engineering, architecture, teaching. These sorts of professions that have an established educational academic path to be able to do them. They're typically subject to some sort of professional certification and licensure. And then prolonged course of study means a specialized academic training is a standard prerequisite for the position. There is this language in the regulations that says typically somebody must have that course of study, or potentially they could have acquired it through experience if it's equivalent to the course of study. That language is a little bit misleading because it really is not going to apply to most people. You really have to have, this is going to apply to the professions where you have to have a degree and you have to have a license. And if you've got somebody who, by some exception worked for 30 years in the industry and then somehow managed to get themselves a license even though they didn't technically have the BA or whatever they needed to do it, then great. But this is not going to apply to somebody who doesn't at least have a bachelor's and probably a master's in one of these fields of study. The other way that people can sort of trap themselves on this is if you have a position that you are classifying as a learned professional exemption and you say somebody needs to have a certain qualification to do it, but then you don't actually enforce that in hiring. So we've seen this come up with social workers. That's one of those that can be on the cusp. Certainly psychologists, psychiatrists, those are going to be exempt positions if they're doing the primary duty of those roles. But when you have social workers out in the field and you are not consistently requiring a certain level of education and a certain level of licensure, that can undermine the exemption really quick, and we've seen that happen to clients in lawsuits. One caveat is there's an exception within the exception for the learned professional exemption. Lawyers, teachers, and doctors are not subject to the salary basis requirement. That's why teachers can get paid the way that they are paid, unfortunately. But it also means doctors can be paid hourly. Nurses cannot. So doctors are exempt from the salary basis, but nurses are not. For them to be exempt, for certain high level nurses, they can be exempt, but they can only be exempt if they're paid a salary.
Yeah, the other place I see this often is with, I touched on it before, accountants. If your internal accountant has to have a CPA and is actually dictating the accounting practices of the business, that would qualify under the learned professional exemption. If your quote unquote accountant is just someone who's been working in accounting for 20 years and their job is to look at the receipts or the AR and look at the profit and loss, creating these profit and loss statements, punching the numbers into the books and generating reports, that's probably not a learned professional. Well, that is not a learned professional. So that's another one where I see clients get tripped up. Well, this is our accountant and there's this exemption. Well, in fact, in the regulations on this exemption, that is a specific example that the regulations call out. There's a distinction between your accountant and your bookkeeper.
Okay, so outside of those big three, which come up the most, there are other exemptions that tend to be in play for most workplaces. We are not purporting to talk about every exemption that exists today. There's a bunch of obscure ones that really never come up for most businesses, but here's a few others that we see with regularity. One is the computer professional exemption, which is its own beast, separate and apart from the learned professional exemption. Also have the outside sales exemption. I actually probably group that one with the big three, white collars, as the four that come up the most often. And then we also have the highly compensated employee exemption, which is kind of the catch-all that can be forgotten about and also can be a tool for employers if you've got somebody who maybe doesn't quite fit into other exemptions. They might be grouped into the highly compensated employee category.
All right, the computer professional exemption. This is one where there's sort of a salary, there's a compensation test here. So you either have to make the salary basis, or if you're going to pay them hourly, they have to make at least $27.63 an hour. And this is another one I see clients get tripped up on a lot. The duties test for this one is very particular. You got to be a computer systems analyst, a computer programmer, software engineer, something of that nature where you are using these computers. It's almost like a learned professional exemption that came along later because, in 1938, they didn't have computer professionals. But you're using these computer science techniques to create things like hardware packages, software packages, system functionality, fixing systems, rebuilding systems, designing systems, some sort of combination of these skills. What this is not is generally not your help desk. The person who you call and says, hello, IT, have you tried turning it off and then on again? That person, if their job is to just kind of troubleshoot your everyday run-of-the-mill problems with your laptop, they're probably not going to fit into this exemption. They have to be the one that's also going in there and working on network protections or designing the systems that you're using every day from a ground up basis. It's like I said, software developers, not help desk people.
Yeah, and this one is one, like Matt said, this has certainly developed since 1938, but I'm pretty sure it was at least 30 years ago when this one came out, so it is a little bit antiquated at this point. I don't think it necessarily captures some of the computer professions that exist now that probably could arguably qualify for an exemption, and that's a way that people get tripped up too. It's not necessarily that this role doesn't seem like it should logically be exempt. It's just that it does not actually fit with the exemption as it exists today. If somebody is not writing software, if they are not the ones actually performing systems analysis, even if they are highly skilled, even if they have a huge level of discretion, if they're user facing, user assisting, it's really not covered by this exemption. Outside sales. So this is one that many, if not most employers have sales folks or marketing folks, and they may have some folks that qualify for the outside sales exemption. This one does not have a salary basis requirement. Outside sales employees, if they truly meet the requirements of the outside sales exemption, can be paid entirely however you want to pay them. They can be paid 100% on commission. They could be paid in some sort of other incentive, hourly salary, combination of all of those things. There's no salary basis. However, they do have, their primary duty has to be making sales. Seems pretty obvious, but sometimes it's a little trickier than it seems. And then the most important is they have to be customarily and regularly engaged away from the employer's place of business or any fixed place of business. And that can be confusing, especially now with so many people that work remotely. Spending all your time in a home office does not constitute being regularly and customarily engaged away, because your fixed home office becomes the employer office. This exemption applies to folks who are regularly all the time in the field, meeting face-to-face with clients, attending sales meetings, attending in-person sales activities. That's going to be outside sales. Again, there's no bright line rule for what regularly and customarily means. There's some guidance that it should typically be about weekly. So you can spend most of the week sitting in an office, but if you meet with a client once a week, we've got an argument that you're outside sales, as long as it's somewhere else. But the common trip up here is folks who do sales duties, they're, unequivocally their primary duty is making sales, but they sit on a computer, they sit by a phone, they never go out and do anything outside of their fixed place of work. They're not going to be outside sales employees.
It's a little antiquated now, but this is your Willie Loman exemption. It started as the door-to-door salesman, and now, we've advanced to probably, coffee house salesman. All right, highly compensated employees. Amanda said this is kind of our catch-all, our backstop exemption. And as you can see, that the floor of this is $107,432. When this was set, that probably was very highly compensated, but more and more this is not getting into that range. It's kind of you're slightly above average compensation exemption. That compensation can be a mix here. it has to at least meet the 684 weekly, and then everything on top of that can be things like commissions or non-discretionary bonuses type things. But if you can aggregate the compensation outside of kind of your discretionary Christmas bonus type thing, then and get to that 107,432, then you've met that mark. Again, we're back in white collar world, so office or non-manual labor. Your electrician who makes $250,000 a year doing these commercial projects, that's not going to cut it. And then the last piece, the duties piece, is can you pull enough from these other exemptions, the executive, the administrative, the professional exemption that we discussed? Can you pull enough from there to determine that this employee is regularly engaged in activities, duties that would fall under one of these buckets, but by themselves might not be enough to reach that duty test. So, like we said, that's the catch-all. A couple years ago, they tried to increase this, but they got pushed back, and the rule was enjoined. It's technically still, I believe, on the books.
Still in the regulations that the minimum for highly compensated employees is in the 150s.
Mm-hmm. But
the DOL isn't enforcing that. They're enforcing the $107,000 threshold from before that was 2018, I think.
Yeah. So, like we said, that's our catch-all. If you're looking at that exemption, my advice would be to talk to an attorney. And if you don't have an attorney you can talk to about this, call us.
All right. Common mistakes and best practices. We've touched on some of these as we've gone through the substance of the presentation, but obviously, the so-called salary fallacy that brings us today. I mean, we still see folks, sophisticated businesses, long-standing businesses that operate under the misconception that if somebody's paid a salary, they're exempt. That is not true. That's never been true. And so that can't be the end of the analysis. We didn't talk about it too much earlier, but another way that employers can mess this up is making improper deductions from salaries. If you have somebody that competently meets the requirements of an exemption, they've got a great salary, they meet the threshold, they're doing all the duties, they've got all the qualifications, but you dock their pay when they miss work, then you're not paying them on a salary basis. There are only very specific situations when you can dock pay and only specific amounts that you can dock for a salaried exempt employee. And if that's something that is becoming too loosey-goosey, then you can lose the benefit of the exemption because you don't meet the salary basis requirement.
Yeah, and a little bit on that, it's a salary basis. And the way to think about a salary is we are paying you to do a job. It doesn't matter how long it takes you to do that job. It doesn't matter if you work from 3 a.m. to 12 noon, or if you work Thursday through Wednesday. We're paying you to do a job. We want that job to get done. If we're paying you a wage, then we are paying you for your time to be at work. And that's where the distinction gets, and that's what Amanda says. If you're deducting pay for time not at work, then you're telling everyone that you're actually compensating that person for their time, not their job.
Yep. And then the converse of that is that you can lose a salary basis if you are paying additional amounts related to time worked that predominate over the salary, or that are too high relative to the salary. So for example, if you've got a salaried employee relying on a salary basis exemption and they get sort of an overtime, which you can do with limitations, but they're paid a salary for 40 hours a week. They work 80 hours a week almost every week, and their overtime predominates over their salary. That's going to jeopardize the salary basis and jeopardize the exemption, because too much of their pay is based on their hours worked. Beyond that, just in terms of applying your exemptions, not reviewing the actual job duties and the actual requirements of the jobs when determining exemption status. This is something that requires regular revisiting. A job may have been exempt when it was created, but it's sort of fallen into a place where the duties really aren't exempt duties anymore. And if you're not regularly looking at that, you could have a situation where you're relying on an exemption for somebody that's just really not meeting the requirements. Similarly, if you're just doing things because it's the way they've always been done or the way everybody in the industry does it, that's not a defense either. It really is a question of, do you meet an exemption or do you not? And then finally, not staying on top of changes to the law. I mean, there's been all these changes back and forth, and it's been kind of a boomerang for the last decade or so of what are the salary thresholds. They go up, they come back down. What's happening with some of these exemptions. So it's something that requires constant work to stay on top of.
Best practices. Amanda touched on this. You need to review what the actual job duties and requirements are for each position. I can tell you that if DOL comes knocking or one of your employees is filing a lawsuit, that the decision on whether this employee was exempt or not is not going to boil down to what you put on the job description on LinkedIn or Indeed or in your files. They're going to look at, what is this employee actually doing day in and day out. And so, as Amanda said, sometimes you write a job description and the person gets there and that role morphs into something completely different from the job description, and those duties are no longer exempt duties. Then you need to be making that change. And so that's why you need to be constantly auditing. What are the jobs? What do the job descriptions say? What are the actual duties? And comparing those two together to create accurate job descriptions. Because yes, I said they're not going to be the be all end all, but they're going to be, if you stay on top of that, that's going to be great evidence if there's ever any question as to whether you've properly classified someone.
But they will be the be-all, end-all if the job description describes a non-exempt job.
Yeah.
So that's kind of the conundrum of being on the employer side, is that you're always the one, you never have the benefit of the doubt when it comes to compliance. If your job description sounds like an exempt employee, you're going to have to prove they're really doing those things. If your job description sounds like a non-exempt employee, well, then they're a non-exempt employee. So just both directions, make sure they're accurate, make sure they're up to date.
And, Amanda already touched on this. Stay up to date on your federal and state law changes. I know we did not talk anything about state law, but, for example, here in Virginia, FLSA matters now for non-compete purposes because the statute changed. We used to have the, salary threshold for whether you are a quote unquote low wage employee who cannot be subject to a non-compete. Which was confusing because that changed every year, and we had to make sure you were staying up to date with what the Workers' Compensation Commission was pushing out, not the Department of Labor and Industry. But you had to stay up to date on that. Now it is tied to their exempt or non-exempt status. If they are a non-exempt employee, they could make $300,000 a year. But if they're non-exempt, they cannot be subject to a non-compete. And non-competes mean more than just you can't go work for a competitor. It can include non-solicitation provisions that prohibit employees from providing services to former clients. So that's a topic for an entirely different presentation, but one that is important. A good example of why you need to stay on top of state law as well.
And to end on a really uplifting and positive note, really, in talking about why it's important, we can't help but talk about, what are the potential liabilities. and we talked about it a little bit earlier, we touched on it, but the remedies for these things are extremely employee protective, and they are very appealing to our friends on the other side of our aisle that represent employees. Because for a wage and hour case, if the employee can find one other employee that is in the same category or subject to the same policies or pay practices that they think don't comply with the FLSA, then you've got a collective action, essentially a class action. And then the attorney can sue your company. They can collect actual damages on behalf of all of the affected employees. They can double those damages, and then they can get their attorney's fees on top of that, which, as you can imagine, is why so many of these cases settle early for a lot of money. So it's somewhat of a cost of doing business, and these sorts of issues pop up, but the best thing you can do is be on top of these practices and be ready to strongly defend those sorts of claims when they inevitably crop up.
Yeah, and if an FLSA case ever gets to litigation, settlement is not as easy as it is in other cases. If we have a client come to us and says, hey, we're being accused of having an employee sexually harass another employee, we can resolve that claim. And to a certain extent, here in Virginia, there are statutes that prohibit the confidentiality, but other non-wage and hour and non-FLSA claims you can settle quickly. You don't need a court necessarily, but for a wage and hour claim, the statute says that you either need to have a federal judge, sign off on the settlement, or the Department of Labor. And so if these issues crop up, to get a valid settlement of these issues, you're going to have to go in front of a judge and defend it. And I can tell you here in the Eastern District of Virginia, the judges do not make that easy. Some jurisdictions will rubber stamp it because it's, why are we bothering with these people who are trying to get out of our court? But the judges here, I've had a judge have us come back multiple times to explain why we divided the numbers, the total dollar amount the way we did. And he kept telling us, no, go back, figure it out. Now, as the employer, our position was that's for the plaintiff and their attorney to work out amongst themselves, because we've told them the total amount we're giving. But we still have to go into the court each time that there's the settlement approval hearing, and that costs you, the employer, money.
And it's all public.
These are not confidential settlement agreements. It is a docket entry that anyone can go look at on Pacer.
So again, ending in that positive way. If there's any questions, we're happy to answer them. We've got a few minutes left. Yeah. So the question for our virtual attendees is, what's sort of the average cost to settle these sorts of claims? And I'm going to give a really lawyer answer and say it depends. But I can tell you that of all of the FLSA cases and settlements that I've worked on, I don't know that I can think maybe a handful were less than six figures. If you have and those were individual plaintiffs where it was clear what the damages were. If you've got a group of employees that has a sophisticated, competent attorney and knows what the employee's rights are, once you start factoring liquidated damages and fees into the settlement, it's going to get really high really fast.
Yeah, I mean, I've been doing this for a dozen years now, and I don't think I've ever had a plaintiff's attorney come to me and say, hey, we're going to file a wage and hour lawsuit. Here's your chance to settle before we do that. They usually shoot first and ask questions later, because it behooves them. Once that case is in court, they know that now the employer has to engage a defense attorney, and we work by the hour. The plaintiff's attorney, they work on, generally they take a piece of what the employee gets or the collective gets, and so they want to file that so that they can, put their chip down and say, look, we're here, we filed a case, we've done this work, give us our attorney's fees, and that's just going to drive the settlement up. I think that you would be extremely lucky to get out of an FLSA case for anything 5 figures or fewer, and that would essentially be you had a dead to rights. We're not, we're clearly not liable for much of anything at all. We have, all the plaintiff's attorney did was file suit, and then we turned around and settled it within, a couple months before anything got, truly into the weeds on discovery or determining the collective or anything like that. But, once you get to that point where, you're issuing discovery, where you're getting the people to opt in to the collective. So just a little background, there's a difference between class action and collective. From a legal standpoint, a collective means that if you want a part of this litigation, you have to affirmatively opt in. A class action means if you don't want to be counted as part of this, you have to affirmatively opt out. And so, you can quickly still get collectives that are, hundreds of employees. And at that point, the plaintiff's attorneys, you're not getting out of there for less than 6 figures. And, it behooves you to settle, because if you get to trial, then you've got, not like we discussed, you've got everything you owed to those employees, then you double it, and then you pay the attorney's fees. And the longer that case goes along, the more hours that plaintiff's attorney is going to work.
They work a lot of hours.
Yes,
they're the most hardworking folks.
Yes.
They really, it's incredible. And I saw another question, and I'll get to you. I just wanted to add, it's an interesting, these cases are unique because of the issue we were talking about, that in order to actually have an effective settlement, meaning an actual release of the FLSA claim so that these folks cannot come back and sue you again, it has to be signed off on by a judge or the DOL. So we actually don't typically settle these cases short of litigation, which is why they tend to get filed quickly, because we don't want to settle them. We don't want our clients to pay money to somebody who actually hasn't effectively released any claim. So yeah, the best defense is a good offense, and making sure you're mitigating as much as you can, ever being in that position. But then once you are, there's a specific type of strategy for dealing with those claims.
My biggest pain point with my sales team, so inside sales, they're taking leads, they're not going out, and their major pushback to go not exempt because, well, then I can't check my email on the Saturday or check a client. Is there anywhere in exemptions that you see a possibility for finding an exemption for inside sales?
So that's a great question. It's not typically going to, it's a very difficult type of job to try to classify as exempt, because it's not going to be administrative. If their primary duty is making sales, then they are not on the sales, they're not on the administrative side of the business, and it's just not going to apply. We've seen that argument play out for loan officers who are usually inside sales, essentially. And the courts have waffled about whether even they can be administrative exempt. So it's probably not going to be administrative exempt. You could potentially have highly compensated, depending on what their take-home pay is. They would have to comfortably be above that threshold. They would have to have a salary basis component, but then their commissions could drive them above that threshold. But again, we'd have to make sure that there's some part of their job that they're regularly performing that meets one of the, the duties of one of the exemptions. It doesn't have to be their primary duty, but we'd have to kind of come up with, are they regularly helping with the administration of a client's business. I don't know what type of sales it is, but that could be a potential way that we could try to get into that territory. But that would be the analysis that you'd have to undertake, is going through each one of the other exemptions and just seeing, is there a way that this fits? But other than highly compensated, yeah.
I can tell you, I've had to do 2 inside sales teams at Fortune 500 companies, from salary to hourly payment. The voice of our in-house counsel. It was a tough move. It's better to start them hourly, because mentally, you're on a salary employee. There's something to it, even though they can make more money hourly, the overtime. But I've had to do 2 large organizations that way.
And the other piece that you mentioned about, well, if they're non-exempt, then they can't check their emails on a Saturday. The FLSA does contemplate de minimis work. Especially these days with the email on the phone, looking at an email on the phone and sending off a quick reply might not meet the level of compensable time. It could potentially be a de minimis thing that you're not going to have to necessarily track. Every time you're checking the phone, you have to log up 0.01 an hour or whatever.
We have one final question that we'll get to from the online folks. If we don't get to this, we'll send these out to you all afterwards, so thank you all for sending these through. The question is, for a completely optional educational seminar or training, does the employer have any obligation to pay for attendance time at the event if the employer pays for travel, food, etc., in order to encourage attendance?
That's a tough question to answer in the abstract. There are set tests that apply to whether time is compensable. I would be very hesitant not to pay for the time of attendance at even a voluntary training if you are paying for everything else, because to me, the paying for everything else is kind of shooting yourself in the foot. In order for something to truly be voluntary, it needs to not be a condition of employment. There needs to be no repercussions for not going, and that might very well be the case. But when you are incentivizing it to that degree, I think you're sort of backing yourself into a corner as the employer of how important is this training and how much are we encouraging it, and are we encouraging it in a way that really crosses the line into this isn't mandatory, but hey, all your colleagues are going and we're paying for most of it. So again, it would depend on looking at the facts of the specific scenario, but you're going to have to apply that to the compensability requirements under the regulations.
I don't really have anything else to add to that. I think that she knocked it out of the park.
Awesome. I think that concludes our time for Q&A, so thank you all so much. We really appreciate it.
Really quickly, I'm just going to wrap us up. I am Diana McMahon. I'm with Unison, and we were partnering with Dominion Payroll today, and just wanted to give you a quick hello and thank you all for being here. Thank you to Dominion Payroll for hosting something like this. We at Unison really believe in kind of that shared knowledge, the connectivity that these types of events offer, bringing the community together, and while very heady topic, very, very important, and important to be proactive. So we appreciate being here. It was great to see all of you, and yeah, we hope to see you soon. So thank you all so much.